Good afternoon, everyone. I'm Rudy Laird, Chair of the Beverly Hills Bar Litigation Section. Welcome to today's webinar, in case you missed it, a review of the top appellate civil cases from 2021. Today, we are honored to have our panelists from the appellate powerhouse, Greines, Martin, Stein, and Richland. Our moderator is Kent Richland, a founding partner of GMSR. Kent has decades of experience as an appellate litigator, serving as lead appellate counsel in hundreds of appeals in high-profile cases and before the California and U.S. Supreme Court. He has served as past president of the California Academy of Appellate Lawyers, and he has received multiple honors as a top appellate lawyer from California Lawyer Magazine, LA Daily Journal, and Chambers USA. Our other two speakers are Jeffrey Gurrola and Stefan Caris, both of whom are very accomplished appellate litigators at GMSR. Jeffrey is a graduate of Yale Law School, and he has the unique perspective from working previously at a large international law firm and also as an in-house litigator. Stefan graduated first in his class from UCLA Law School. Upon graduating law school, Stefan worked at a large law firm and then clerked for the Ninth Circuit Judge Paul T. Watford. Stefan also holds a PhD in music theory from Eastman School of Music. Before we begin today's program, I also have two quick reminders. First, please mark April 22nd on your calendars for the next installment of our popular War Story series. This is a program created by Alexander Rufus Isaacs, featuring the very best of our legal community. This next installment on April 22nd will highlight Yakub Hazard of Mitchell Silverberg. Mr. Hazard is a go-to litigator in entertainment and IP practice. The moderator for the program will be the talented entertainment transactional attorney, Holly Brown. For my second reminder, BHBA's programming and success, I'd like to say, depends on viewers like you. If you have ideas for the litigation section program, if you're interested in getting involved or know of others who are, please reach out. We welcome practitioners from every area of practice, business litigation, family law, probate and estate, criminal. We welcome diversity both on our executive committee and in our programming. If you do have the time, I think you'll find it incredibly rewarding. Now for our program today. If you have questions, please direct them in the chat to the panelists. If time permits, the panel will address questions at the end of the program. CLE certificates will be issued to attendees via email within 24 to 48 hours of the program. And with that, it's my pleasure to hand the virtual mic over to you, Ken. Thank you very much.
Thank you, Rudy. Appreciate it. And thank you all for attending. I want to give you a little bit of an idea of the process by which we've chosen these 20 cases that we're going to talk about today. We've culled them from the literally hundreds of published opinions that have come out of the California Courts of Appeal and California Supreme Court for the past year. And our criteria for choosing them has been a little varied. Certainly, we've chosen cases that decided issues of first impression, but we've also looked at cases that gave a new kind of tilt on already decided issues and cases that did a really good job of just explicating the law. Bottom line is that we think that these 20 cases are ones that if you encounter an issue that is mentioned or decided in one of these cases, you are almost certainly going to want to have reference to these cases because they will be the most recent word on those particular issues, and they'll be some of the best words on those issues. In fact, we've even included a couple of criminal cases because those cases, because of the issues they decide, would affect civil cases as well. So I'd like to ask you also to please download the detailed outline which we've provided, and that outline lists all the cases, summarizes what we have to say about them, and also includes other recent cases that are related to those issues. That being said, let's start off, and we'll start with Stefan, who will talk about a case that has to do with jurisdiction and service issues. Stefan? And next slide, please.
Thank you, Kent. And this is Searles v. Archangel. It's about service of process. We have a lady named Queen Searles, and she was being harassed and stalked by a man named Michael Archangel, who seemed to be homeless. And she sought a civil restraining order against him on the basis of this conduct. And she was having trouble serving a copy of the petition for the order personally, as the statute required. So she asked the court, could I serve him by social media, specifically by Facebook? She knew that he followed her on Facebook, so she had a good argument to the court that he would see this this form of service, and she was also going to push the petition to other social media platforms. And the court thought this sounded like a great idea. The court has a nice summary of other jurisdictions that have approved service by social media, but the court ultimately said, I can't allow this here because the statute under which she sought this petition specifically names personal service as the only means. And so even though another section of the Code of Civil Procedure, 413.30, allows methods reasonably calculated to give notice, this section is available only when the section under which somebody seeks relief doesn't specify a form of service. But because she sought relief under this other provision, 527.6, that requires personal service, she had to follow that method, no matter what kind of showing she could make about how likely the social media service would succeed. So there's a useful lesson here that the flow chart of forms of service that we all have in our minds, you can use this method or this method, and it's all got to be reasonably calculated, doesn't apply if the statute you're operating in specifies a method. So you can go to the next slide, which is also mine. And in this case, this is, again, a case about a kind of gateway or threshold issue, Contreras v. Superior Court. What we have here is a group of workers of an online ride service platform, and they signed an arbitration agreement as a condition of their employment. The agreement delegated jurisdictional and arbitrability disputes to the arbitrator. These workers tried to bring labor code private attorney general claims against the employer based in part on misclassification as contractors when they're actually employees. This raises a tricky legal issue because private attorney general claims are not arbitrable, but they're also only available to employees, aggrieved employees. They're not available if these workers are contractors. So the merits question of how these workers are classified ends up being the same as the jurisdictional question, whether they can bring these kinds of claims at all. So the question before the Court of Appeal is, given that they signed this arbitration agreement that gives the arbitrator responsibility for gateway questions, should the arbitrator decide, are these workers employees or contractors? Or should that question go to a court? The Court of Appeal said that question has to go to a court. This has to do with the nature of these private attorney general claims. They belong to the state, and the state hasn't waived the right to seek relief in court. And so even before we've determined that these workers can bring these claims because they're employees, the state still gets to argue that point in court. The state can't be forced to arbitrate that point, no matter what this arbitration agreement might have said about threshold disputes. And you can go to the next slide.
Thank you very much, Stefan. And this is my case, Fisher versus Moneygram. And this is an absolutely superb opinion by Justice John Streeter from up in San Francisco. It's really the most recent comprehensive explanation of the unconscionability doctrine as applied to an arbitration clause. And what is particularly good about this opinion is that not only does it explain the law beautifully, but it also actually reproduces in an appendix the particular arbitration clause that was found unconscionable because of the fact that it was almost illegible. It was written in 6-point type. The spacing was terrible. It was essentially an arbitration clause that was written on the other side of the little contract that the plaintiff filled out. And this is a great case to just have handy when you have any issue concerning unconscionability. It covers all the law, and it's also a case that you can show a client if there's a question as to whether their clause is or is not unconscionable procedurally, because it actually shows what a procedurally unconscionable clause looks like. Next slide, please. And this is Jeff. You're going to talk about this, right?
Yep. And actually, really quickly, to piggyback off of Kent's point, these aren't included in our presentation today. There's actually, for anybody who does arbitration related things, there is a pair of decisions out of the 4th District Division 1, one at the end of last year and one about 2 weeks ago, evaluating the enforceability of those sort of ubiquitous online terms of use agreements that that we all deal with and that all have arbitration agreements in them. So those are called they're called BD is one and Sellers is the other. I wish I had the sites for you guys, but similarly interesting arbitration decisions. So my case is Harris v. Thomas D. Engineering, and this is a mesothelioma case that arose when the decedent's wife, the decedent had been a worker in the Navy. He worked on a ship, and they were doing renovations to the ship that involved tearing out the asbestos or the insulation around a boiler that had asbestos in it. And at his deposition, the expert for the plaintiff testified that if the decedent wasn't present when the removal was being done, then there wouldn't have been any exposure to asbestos. In opposing summary judgment, the same expert offered a declaration with revised opinions. And at this point, the expert said that the fibers can actually stay in the air for as long as 80 hours, meaning he didn't actually have to be present at the time of the removal itself. The contractor who was sued opposed summary judgment or challenged on appeal on the idea that the declaration was not admissible at trial because it was outside of the scope of the expert's deposition. The Court of Appeal shot that down on the basis that it wasn't inadmissible at trial. It was potentially admissible at trial because it's subject to the court's discretion whether to allow an expert to file late opinions subject to sufficient notice and potentially opportunity to be deposed again. So because it wasn't inadmissible, but was instead potentially admissible, it was allowed in the face of that challenge. The second challenge was on the D'Amico sort of sham declaration, which a lot of you are probably familiar with, but it's this idea that if you originally came up with plaintiffs who had made admissions, but then gave totally contrary declarations to defeat summary judgment. And the court said that this is a rule going to weight, not admissibility, the D'Amico rule, and also that the expert did not contradict prior factual assertion, but instead gave a new scientific theory based on the same facts. And you can go to the next slide.
Thanks very much, Jeff. This case is Mostafavi Law Group, and it's a case involving an issue about settlement. And quite frankly, the result in this case, I think, is not expected. And therefore, this case really sort of presents a trap for the unwary. it has to do with the a settlement offer made under CCP section 998. And as you know, where there's a 998 settlement offer made and it is turned down, if the outcome of the trial is less favorable to the person who turns it down, that party then has to pay costs. So what this case involves is an offer made under 998 that was accepted by the other side. The problem is that the offer under 998 was defective. It didn't include what the statute requires, which is a provision for acceptance. And because there was a provision, no provision for acceptance, the court held, it was not a valid section 998 offer. Now, it was still an offer and it was still accepted. In fact, it was accepted in writing by the other side. So, common sense would say that under contract law, this was a fully enforceable settlement. But the Court of Appeal holds, no, it's not. It holds that where an offer is made under section 998, it must comply with all the statutory requirements or it's a void offer. The offer itself is void. And even if accepted, it is not enforceable. So here you had a party that was quite happy to settle the case. Judgment was entered on that settlement, and the Court of Appeal then held that the judgment and the offer were both void because they were defective under section 998. Next slide, please.
This is another section 998 case, Kosravan versus Chevron Corporation, maybe with a little less surprising or unexpected of an outcome. This is interestingly another mesothelioma case, but the plaintiff slash decedent worked at a plant affiliated with Chevron in Iran, several decades back, and also ended up coming down with mesothelioma and dying in the course of litigation. Chevron made a section 998 offer that required not just a waiver of claims, which is pretty standard, but for the plaintiffs to indemnify Chevron for any claims based on the same theories of liability, potentially to be brought by other members of the family who weren't plaintiffs at that time. The Court of Appeal said that this indemnity provision rendered the section 998 offer too difficult to value. And this was even so based in the face of Chevron's argument. So Chevron ended up prevailing. They did get a more favorable judgment. The plaintiffs failed to get a more favorable judgment. And so Chevron wanted their costs. And the court and Chevron argued, well, these were, completely baseless claims. So they had no value. There was nothing to indemnify. And the Court of Appeal said that's not, that doesn't save you because, for instance, there's a good likelihood they would be required to indemnify you under the terms of the agreement for your defense costs. So because of that, that provision, that indemnity provision in the 998 offer, it rendered it incapable of valuation, and therefore they could not do the cost shifting under 998. And next slide.
Thanks, Jeff. The next case is one that was written by Justice Leandra Kruger of the California Supreme Court. And I have to say that California got very lucky when President Biden appointed Ketanji Brown Jackson to the US Supreme Court, because that meant that he allowed us to keep Leandra Kruger. And she is an absolutely superb justice. She is one of the most prolific justices, has written a lot of opinions, and her opinions are always very thoughtful, very helpful, very carefully reasoned, and go into a lot of depth and detail about the law, explaining some of the most difficult issues of law. This case involved an issue that has been problematic for California lawyers for probably as long as California has been a state. It has to do with the fact that a prohibitory injunction, when granted by a trial court, goes into effect immediately. It is not stayed pending appeal, but a mandatory injunction is automatically stayed. Now, this is really important because the effectiveness of an injunction may depend on how quickly it goes into effect. And so deciding whether something is mandatory or prohibitory can be, in some cases, the whole ball game. Okay, what did this case involve? This was a case in which the lower court had held that the defendant had violated the Brown Act, and therefore it ordered an injunction that required the defendant to remove and replace a member of the Board of Supervisors. On appeal, the question was this a mandatory or prohibitory injunction? And frankly, it can be argued either way. And that's true of a tremendous number of injunctions. Justice Kruger goes into the history of this. She explains in some detail how it can be argued either way. In fact, what she says is that she has a long footnote, footnote 10, where she literally explains how various injunctions in past cases could easily be categorized either as mandatory or prohibitory. So if you get a case involving this, obviously you want to read this opinion because it will give you your argument. She then postulates a solution for this problem. Now, she doesn't make the solution herself. She says this is something really for the legislature because this has been the law in California since before the Code of Civil Procedure was enacted. But she says what the legislature should do is it should require what is essentially an equitable analysis of whether a stay is requisite or not in an individual case. And the issues that would be decided were, one, how likely is it that the injunction will be upheld? And number two, which party, if either party, will incur some kind of irreparable injury if there is not a stay granted. Now, even though Justice Kruger says this is something that I think the legislature should enact, my guess is that from now on, when this issue is decided, parties are going to be briefing these equitable issues. They're going to be arguing them because they've now been raised as a potential basis on which a decision has been made. And so along with the mandatory prohibitory analysis that you obviously have to follow, I think this introduces a new and perhaps a much better way of deciding this issue. Next slide, please.
Okay, so People v. Ascona, we turn to the topic of scientific expert testimony. And this is one of those criminal cases that Kent mentioned that actually has a lot of relevance to civil cases as well, to the extent they deal with scientific expert testimony. So the defendant, Brad Ascona, was convicted of multiple murders at multiple crime scenes. And the prosecution put up an expert to get the conviction, who testified that bullet casings found at the different scenes all came from the same gun. The expert compared marks on the casings to reach this conclusion, and he put his conclusion in very strong terms. That's much more than can ever happen by chance, he said about the similarities. He said his method led to the practical exclusion of all other guns. The defendant tried to rebut this testimony by putting up studies that called into question the method the expert used. So as background here, in California, as you may know, scientific expert testimony is generally admissible if the method relied on is accepted in the relevant scientific community. And this expert's method was generally accepted, notwithstanding these studies the defendant put up. So the courts in California can't independently reject a method if it's accepted by the science community. So the Court of Appeal said, okay, the trial court was right to admit this testimony in general, because this guy did use a method that is accepted. But the Court of Appeal said the trial court should not have admitted the portions of the testimony that express the conclusion so strongly, because that level of certainty that the expert expressed went beyond what the methods could support. And this is an important holding here because it it reminds us that even if a scientific expert on the other side is relying on a generally accepted method, and so we can't keep the whole, all the testimony out, we can look carefully to make sure the conclusions the expert offers and the level of certainty behind them is supported by that method, because there's room to argue to exclude portions of the testimony on that basis, even if the method as a whole has to get admitted. Next slide, please.
So this is another one of those criminal cases that has pretty broad impacts in the civil world. If anybody's done a trial in the last several years, you've probably, and that had experts, you probably encountered Sanchez. Sanchez is the basic rule that you can't sneak in case-specific hearsay through an expert. You have to prove it by independently admissible evidence. In this case, the Supreme Court gave a lot more information on what it means to be case-specific. In this case, there were two defendants being charged for crimes, and the people wanted to get gang enhancements. That requires proof of quote unquote predicate offenses, which are other offenses committed by members of the same gang on past occasions. So the people called a police officer expert, and he came and testified about three totally different people and their past crimes, but that were members of the same gang. On appeal, the Attorney General argued that because these didn't actually apply to the case at hand, the specific alleged crimes of the two defendants in this case, they weren't case specific under Sanchez. And the Supreme Court said that that wasn't correct and gave more contours to what it means to be case specific. And ultimately, the line that they drew was whether this sort of hearsay information is of a type that's generally known to experts in the field. Using the gang, the specifics of that case, that would be things like gang territory, gang colors, things like that, reputation that would be known to a gang expert, versus information that isn't generally known in the field. And that would be, again, the specific offenses of specific people. So in briefing these, Sanchez motions, there's a very common motion in limine. This really gives a lot more clarity and a lot more ammunition to anybody who is trying to stop the other side from bringing in hearsay through an expert. Next slide.
Okay, now we come to two torts cases in a row, and I have both of them. The first one is Isakani v. Shadow Glen Homeowners Association. And this concerns the potential liability of a landowner for not having enough parking spaces. What we have here is a visitor, the plaintiff was visiting a condo complex. She couldn't, and it was nighttime, she couldn't find a parking space. She ended up parking across the street. Because it's a torts case, when she tried to cross the street to the condo complex, she was struck by a car and seriously injured. And she sued the complex for negligence and premises liability. As background, she sought liability on, or she argued liability on two grounds. First, common law duty of care to provide these spaces. And second, there was an ordinance under which this complex had been zoned. The nature of zoning in LA actually requires a single unit getting, or a single property getting rezoned, has a whole ordinance just about that. So this property's rezoning ordinance actually specified a number of guest parking spaces, and the complex did not have enough parking spaces under that ordinance. So she said either of these theories establishes liability here for not having enough spaces. The Court of Appeal did not agree. The Court of Appeal joined a number of prior decisions saying there's no common law duty to provide sufficient parking for guests or for residents. It's a pretty well-established conclusion, and it's just kind of flows from the public policy interests behind whether courts impose a duty of care or not. The Court of Appeal also rejected the idea that the ordinance gave rise to a duty of care. Not every ordinance or law creates such a duty. This one didn't for two reasons. First of all, it wasn't about a general public policy. It was just a rezoning ordinance about this land. So without some kind of broader public policy being established, an ordinance is not really going to create a duty of care. And second of all, setting that first problem aside, this ordinance didn't even have the purpose of enhancing safety. It had actually an aesthetic purpose to avoid overcrowding nearby streets with parked cars. So even if this had been some kind of broader public ordinance, since its purpose wasn't to protect safety, it wasn't going to create a kind of safety-oriented duty of care to have these parking spaces. Next slide, please. Gonzalez v. Mathis is a Supreme Court decision about similar issues, but this is actually the liability of the hirer of an independent contractor for that injuries that that contractor or the contractor's employees receives during work. What happened here is a homeowner had hired a window washer to clean his skylight. The window washer fell off the roof in the course of cleaning the skylight. And window washer was an independent contractor and sought negligence or in-premises liability based damages. Now, there's some background here, which you may know or which you might want to refresh your eye. Under this 1993 decision, pre-vet, it's very well established that generally the hirer of an independent contractor is not liable for the contractor's on-the-job injuries or the contractor's employees' injuries. There are also two known exceptions to this rule. One is when the hirer retains control over some aspect of the safety, and the other is when there's a concealed hazard on a landowner hirer's land that the landowner hirer has a duty to disclose to the contractor. So those are the known exceptions. But what the new issue in Gonzalez was, we have actually a known visible hazard, the roof, but it's one that the contractor can't protect himself against. So for that kind of hazard, does the hirer bear the risk of liability? The Supreme Court said no, the hirer is not responsible for protecting the contractor from a known hazard, even if it's one that the contractor couldn't protect themselves against. The reason for this is to impose liability in this situation would actually invite the hirer to assume control over an aspect of the employment, which is exactly what Hooker, this retained control case, says, oh no, as long as you don't assume control, you're in the clear. So it created a catch-22. Basically, the contractor remains responsible for their own safety, even if there's some kind of insoluble problem on the property. The contractor is the one who needs to bring that up to the hirer. It's not the hirer who needs to solve that problem. Next slide, please.
This is another California Supreme Court case that sort of settles something that you would have thought would have been settled a long time ago. And it's a question of when the statute of limitations begins to run and how it's computed for people who turn 18 and the tolling period ends. As people generally probably know, the statute of limitations is tolled for minor plaintiffs and begins to run on their 18th birthday. The plaintiff here sued the city of Fontana. He turned 18 on December 2nd, 2011, sorry, December 3rd, 2011, sued on December 3rd, 2013. And the city said that the first day should have been included such that he was off by a day. The Supreme Court said, with a background that statutes of limitations in particular are supposed to, be interpretable consistently and predictably. And anybody who's litigated statute of limitations issues knows that that's often still not the case despite the court's efforts. So when the city said, well, the reason that you don't count the first day, which is a basic rule, I believe it's Code of Civil Procedure, Section 12, the reason you don't count the first day is that in an ordinary case, you're injured on the first day. There's a partial day. The law doesn't recognize partial days, so you start on day one, and that doesn't exist. That same sort of policy rationale doesn't exist when a minor is told and then turns 18. The California Supreme Court said whatever value that reasoning has in most instances, ultimately, because of the need for predictability and the need for consistency in statutes of limitations, plus the plain language of Section 12, that unless the legislature clearly and explicitly expresses some sort of contrary intention in a statute of limitations, then it will always be that you do not count the first day and you do include the last day. So for minor cases, that means you do actually get one 366-day year. Unless it's a leap year, then it's 367. Next slide.
Thanks, Jeff. And this case also involves an issue that you would have thought would have been previously decided. It's a medical malpractice case, and the opinion was written by Justice Brian Hofstadt, who's one of our best Court of Appeal justices. And here's the issue. Does a patient's fully informed consent to a medical procedure negate the physician's liability for the negligent recommendation of that procedure? In other words, the patient is told, here are the benefits and here are the risks of this particular procedure. But can the patient say, notwithstanding the fact that I consented, this should never have been recommended in the first place? Well, the opinion concludes that in fact, there is no such negation under these circumstances, and explains it as, look, only if no reasonable physician would have recommended that procedure in the first place is there liability. And that really has nothing to do with the patient saying that they want to go ahead with the procedure or not. They're the patient. They don't have all the information. It's the doctor that has all the information. So the conclusion is, no, there is no negation of liability under those circumstances. Next slide, please.
Okay, now we turn to two products liability cases in a row. The first is Piliad v. Monsanto. And this case concerns the consumer expectations test for whether a product is safe. Factually, we have a couple who does a lot of gardening, and they use copious amounts of Roundup to kill the weeds in their yard. And they do this over the course of decades with no safety gear, and they both get cancer. It's a very sad story, and they bring suit against Monsanto, goes to a jury trial, and the jury is instructed about consumer expectations as the basis for whether to find this product to be safe. Their argument, the couple's argument, is that the bottle or some other warning should have been in place that they need to use safety gear to use this product safely. Now, Monsanto argued there's really conflicting data about cancer. That's a complicated issue. Consumer expectations here, that test doesn't apply because consumers couldn't reasonably expect this product would or would not cause cancer based on what they know. That's kind of exceeds what an everyday consumer would know. But the couple agreed, with which the court agreed, said that's not the right way to think about the test here. The test is whether the consumer would think this product is safe to use without safety gear. Not necessarily that they would know about a specific hazard that the product does or does not have. Now here, since the bottle said nothing about safety gear, and since the ads for Roundup showed people using it without any protective gear, the jury was properly instructed and reasonably reached the view that the I should say the ordinary consumer would expect to be able to use Roundup without protective gear, and therefore the label was not a safe product because of the failure to warn on that point. There's other issues in the case, but that's the most interesting one. Let's turn to the next slide, please. We have Loomisv Amazon.com. A woman, the plaintiff, bought a hoverboard on Amazon through a third-party seller. I'm sure we're all familiar with how some products on Amazon are sold by Amazon. Some are Amazon processing or somehow clearing or brokering a sale that is ultimately consummated by some third-party seller. So anyway, this plaintiff bought the hoverboard through a third-party seller. It injured her, and she sued Amazon on a strict products liability theory and a negligence theory. The question is, does Amazon's role in this transaction open it up to those forms of liability? And the Court of Appeals said, yes, it does. As background, it's accepted and established that manufacturers and retailers are strictly liable for product defects. And as for other entities in the kind of marketing and production and distribution chain, there's a kind of factor test, pretty squishy, that courts can apply to decide whether those other kinds of entities could be open to strict liability. The Court of Appeals said no matter which of these tests you apply, Amazon is open to strict liability and to negligence product liability. Number one, Amazon is essentially the retailer or distributor. It controls all communication with the customer. It has the warehouse space where this good is being stored. Even though we have the digital platform, it's essentially a retailer. So classically, that makes it open to strict products liability. And second of all, when you apply this kind of squishier factor test, Amazon clearly satisfies it. Another avenue to its liability. Now, this was not path-breaking law, but perhaps the most worthwhile part of this decision is actually a concurrence by Justice Wiley, which is this kind of ode to tort law about this judicial quest to minimize the social costs of accidents. Where he goes on about the history of tort law and its development, particularly products liability, but really in lots of spheres. And I would highly commend this concurrence to you, whether you represent plaintiffs or defendants, because he actually offers a set of cases on both sides to illustrate the beauty, the intuitive beauty of tort law. So check that out if you ever litigate torts kinds of cases. And we can go to the next slide.
I was recently recommended by somebody to read Justice Wiley's opinions in general because he's a fantastic writer, and having done so, I agree. This case is on in the subject of employment. And so sort of as background, for a long time, California was facing a problem where employees who experienced wage and hour violations and sued for them, they would be facing judgment-proof shell company employers and wouldn't be able to either get a judgment or collect if they did. And so the legislature enacted section 558.1 of the Labor Code, and that made it so that you could sue the employer or another person acting on behalf of the employer who caused or allowed to be caused, I believe is the language, the section to be violated. And a person that is acting on behalf of an employer is defined in the statute, and it does include an owner. So in this case, we had an owner of an LLC. The owner of the LLC lived in California. It was an Iowa LLC. Other than signing a couple forms when the LLC was formed many years ago, she had no involvement in its management or its operations. And so the question that the Court of Appeal was presented was, what does it mean to be to cause a violation under the statute? And they settled it in really what you would expect the court to settle it in terms of interpreting it in its plain language. they said that the person either needed to be directly involved in causing in the violation itself, or the person needed to be sufficiently associated with the violation, such as in a supervisory role, where you had a sufficient nexus between the actor and the ultimate violation. And in this case, the plaintiffs argued, I think their main piece of evidence was that this woman's signature appeared on the paychecks that they got. But the Court of Appeals said, that wasn't enough because that was a signature that was signed when the corporation was formed and just stamped by the bank on every one. So it really is a test of looking at the sufficient nexus between the owner or other person acting on behalf of the employer and the specific violation in the case. You can go to the next slide. So this one is sort of factually interesting. It's also a very, very long case and kind of esoteric, except for it really establishes, a good example of the sort of tension between insurance policies being construed according to their plain language, like any contract, and insurance policies being construed in favor of the insured. In this case, the Coptic Orthodox Church up in the Bay was buying a house for the Pope of the Coptic Orthodox Church to use as his Western United States papal residence. He lives in Egypt. And they purchased the house. It was empty. And they got a homeowner's policy as was required, as a condition of the loan. And then after they had been in possession, after escrow closed and the policy had been in effect for 60 days, somebody on the property noticed that there was a leak and water damage. The policy contained an exclusion that said that it will not cover water damage if the property had been vacant for for 60 or more days, or more than 60 days before the date of the occurrence. Now, in this case, the plaintiffs argued that that the policy had only been in effect for 57 days, and so the fact that the building had been vacant before that time shouldn't count against them. And the Court of Appeal disagreed. They said that the language was unambiguous, that 60 days meant 60 days. It didn't mean 60 days from policy inception. And that vacant was also, plainly, it was defined in the policy. And this place, it only had like a chair, some toilet paper, and a plant, in the whole house. So they didn't have any trouble finding that it was vacant. But yeah, actually, you can go to the next slide. So this is a damages case. This is sort of interesting for anybody who's ever done UCL claim cases, which damages are not allowed under the UCL. Restitution is the only monetary remedy in a private UCL action. And the whole point of restitution is to sort of restore the plaintiff to the status quo ante by returning any property that was taken from them or in which they had a property interest, even if they didn't technically possess it at the time it was wrongly taken by the defendant. In this case, an optometrist sued a competing chain of eyewear retailers under the UCL, and they sought restitution in the form of lost market share. What they said was the market share that was wrongfully taken from them through this unfair competition. The Court of Appeals said, this case is squarely within one of the seminal UCL cases, restitution cases, which is called Korea Supply. You've probably heard of it, and it held that non-restitutionary disgorgement of profits or of money isn't allowed. It has to be restitutionary in nature. While restitution extends to any funds or property in which the plaintiff has, like I said, a vested interest, in this case, a business doesn't have a vested property right in market share. And they actually added sort of a discussion explaining why that is a sort of logically absurd and anti-competitive notion, in that you would be able to sue anyone anytime they took a customer from you, essentially, if you had a vested interest in your market share. So because of that, they said that you can't recover, future lost profits, no matter what you call them, in the guise of restitution under the UCL. And they left open, very explicitly, they left open for another day whether, if the people in this case or in any other case had a contractual promise or an enforceable contractual guarantee to some sort of future income, whether that would be recoverable as UCL restitution. Next slide.
The next two cases I'm going to talk about, the last two cases, and both of them have to do with damages. The first one is this Briley versus City of West Covina case. And this is that extraordinarily rare animal of a case in which an appellate court concludes that as a matter of law, the non-economic damages that were awarded is not supported by substantial evidence. It really happens only once every decade, I would say, that there's a case like this. And if you look at the damages that were awarded in this case, the wrongful termination case, $2 million award of non-economic past non-economic, and 1.5 million in future, you wouldn't think those sound terribly out of line. But what the court says here is, and the way it analyzes the issue is what's of significance. And it's something to really pay attention to if you ever are involved in a case of this sort, because what the Court of Appeal says is that the future non-economic damages have to be viewed in light of the fact that there was a substantial award of economic damages. And for that reason, the court concludes, the plaintiff is not going to have a lot of future non-economic damages. The plaintiff is not going to be terribly worried. There was no testimony in this case that there was severe effects on the psychology of the plaintiff or anything of that sort. And so the court is actually doing an analysis, which I'm not sure it would be second nature to all of us, that the entire damage award has to be looked at together to determine whether any one portion of the damage award might be excessive. The other thing that the court does here that is somewhat unusual, doesn't really explain it, but rather than just simply reducing the award, it actually issues a remittitor, or says that if the plaintiff doesn't wish to accept the remittitor, there would be a retrial of the non-economic damages portion of the trial. Most of the time, appellate courts don't pay too much attention to that kind of nicety, and will just simply order a reduction if they feel that it's necessary. But really, the law behind why remitters exist at all, they exist mostly in the new trial area, is because courts can't unilaterally decide issues that are jury issues. And so long ago, the California Supreme Court said that a trial court can't issue it must issue either a choice of a new trial or a reduction of damages. It can't simply order a reduction of damages. Well, that's what sauce for the goose is, sauce for the gander. It seems to me that the Court of Appeal is entirely right, that it really has to follow the same kind of procedure. And this court did precisely that, even though other courts haven't in the past. Next slide, please. And the last case I'll be talking about is Morgan versus JM Manufacturing Company. And it's a case involving punitive damages, and it really provides a new wrinkle on punitive damages against a corporate defendant. Civil Code Section 3294 says that where punitive damages are based upon the acts of an employee, they cannot be awarded against the corporation unless an officer, director, or managing agent approved the conduct of the employee. Well, that raises the question more generally about what needs to be shown in order to achieve punitive damages against a corporation. And what the court here holds is, and it effectively expands what is required to be shown to hold a corporation liable for punitive damages. It says, look, there always has to be some evidence from which a jury can infer that policymaking officials in the company possess the requisite malice. In other words, it's not simply enough to show that something terrible happened. That's not enough on the basis of that to infer that there were policymaking individuals who knew about that and approved of it. There must be actual evidence that policymaking officials were aware of whatever it was that gave rise to punitive damages. And then that is the only basis on which punitive damages can be awarded. In this case, the Court of Appeal reversed a $15 million punitive damage award on this very basis. So that concludes our review of the law for the past year, the important cases that we've identified, idiosyncratic as that may be. Just as a bonus for the people that have really stayed with us and are still here, I wanted to add a couple of things that you should be watching for in the future. One is that any of you who have followed the decades-old battle between the California Supreme Court and the United States Supreme Court over the right to arbitration or not arbitration, will be aware of the fact that the way this landscape looked last was that the California Supreme Court decided the Isakani case, which permitted the held that you could not waive, an employee could not be made to waive a private attorney general cause of action, and therefore even an arbitration clause that provided for such a waiver was not effective. And the United States Supreme Court denied cert in the Isakani case, the case that held that. Well, hold your horses, because on the 30th of March, there was an argument in the United States Supreme Court, and at least from the questions, and you can't always depend on the questions, but at least from the questions, it looks as if a majority of that court is going to say, no, even that is in effect made outlawed by the Federal Arbitration Act. So the battle goes on. With that little bonus, we're happy if we have any time to answer some of the questions. Rudy, do you know what questions?
I saw one note asking about, I think, Shalabi in terms of the date, and the materials are correct. It's December 3rd. And I wasn't scanning to see any other questions, but I noticed there was one comment here, and I want to echo it, saying it's one of the best programs attended in the past 35 years. And I think that hits it on the mark. The materials are excellent. And it's not easy to encapsulate an entire year over the course of 60 minutes, but you did very well. And I highly recommend our attendees look over the materials, pull the opinions. A lot of time was put into this to select really the best cases for you across a wide practice area group. And I want to thank you all, and I really salute you, Kent, Stefan, and Jeff. Thank you very much for an excellent program. Thank you.
Thank you so much, and thanks to everybody for attending.
All right. Well, until next time, thank you everyone for attending, and we appreciate you attending. And again, thank you very much to the panel for an excellent program.
Thank you.
Bye-bye.